All right. Good morning, everybody. Welcome, welcome. I hope everyone is doing well this morning. My name is Dana Sparks. I am the director of the Georgia Real Estate Academy, and today's class is the 2022 RE Forms Contract Dissection, class number 73906. So I hope everyone is in the proper place. So just a couple of things before we get started. This is a virtual CE class, obviously. And so the way GREC monitors attendance for our school is via the chat function. So if you have already done so, you guys do not need to do it again. But if you have not already done so, in the chat feature, please type in your name, your real estate license number, your email address, and your phone number. I'm going to ask you to do that 3 times. Now, at the beginning of class, when we come back from break, and then before you leave. Additionally, I am going to ask questions and ask that you guys type in your answers in the chat. There might be a time when I have gone on and already given you the answer before you've had the opportunity to type it into the chat, but go ahead and type it in anyway. That way we can demonstrate to GREC ongoing student participation so that to prevent you from just turning on the computer and walking away and coming back 3 hours later. Not that you'd ever do that, but just so you know, that is how our school, the Georgia Real Estate Academy, does demonstrate class participation and interaction and attendance the entire time of the class. So we are going to get started. I do have handouts that I will email to you guys after class. You do not need them for class. Everything I'm gonna cover will be in the PowerPoint, but if you're like me, I like having something tangible in my hand. So I will email you handouts that do have, it will be a PDF of these slides, and it will be the RE forms with all my red underlines and all my notes and all of that good information. So we are going to get started. If you do have questions, also, just type them into the chat and we will get started. So I'm going to share my screen. Oh, share, yep, share, there we go. And let me move this over so I can see it. And we will start the slideshow. And here we go. All right, let me make this small. All right. As I mentioned, this class is the 2022 RE Forms Contract Dissection. Some people refer to them as the FMLS forms. I guess that's because that's where most agents, at least in Metro Atlanta, get readily available access to them is in FMLS, but they are available in Georgia MLS and in various MLSs. If you're with a brokerage that has .loop, I'm not sure if your broker has uploaded those or not, but they are. We'll go on a little bit more about the forms themselves. It is GREC number 73906. I am the instructor, Dana Sparks. I am the director of the Georgia Real Estate Academy, which is GREC School 6915. In addition, I am the qualifying broker of Maximum One Greater Atlanta Realtors. The only reason I tell you that within the context of a contracts class is to let you know I am what they call a non-competing broker, meaning I do not interact with the public in a sales situation. I don't help buyers and sellers anymore. I manage the company, I teach, and I support agents, and I deal with co-op brokers and co-op agents and things like that. So I'm not dealing with contracts on a day-to-day basis from an agent perspective, but I am dealing with contracts on a day-to-day basis from a broker perspective. Now, I'm not our compliance broker. We have a completely separate compliance broker who reviews every single contract. I just get the ones that have interesting issues, with my air quotes, or questions, or some challenges, or things like that. So, you know, I say 1 or 2 a year. But I just wanted to give you a little bit of context that I do see contracts on an ongoing basis, and I am familiar with the market, the challenges, as well as the excitement and the opportunities that you guys as agents are dealing with in today's market. And just for context, this is September of 2022. Again, the school renews the end of this year, so I need to send in that renewal. It is GREC School 6915. This is the course RE 2022 RE Forms Contract Dissection GREC course number 73906. This is a classroom or remote broadcast of an approved in-class course, 3 hours in duration, approved for continuing education. No prerequisites, and no homework and no final exam. Just so you guys know, you may only take one virtual CE class at a time or with overlapping times, regardless of the school offering the course, in order to get CE credit for either course. Just because they're virtual, you cannot have 2 computers open and take 2 CE classes simultaneously, whether they're offered through the same school or different schools. I mean, just think about it. Physically, you could not be in 2 places at one time. So GREC will not give you credit for either course if it is discovered that you are taking 2 simultaneous courses or with the times overlapping. Again, I am the instructor. As I mentioned, how we are keeping up with attendance is via the chat function, and you may only receive credit for a specific course number once every 12 months. If you've already received credit for this class within the last 12 months, you're more than welcome to attend, but you won't receive additional credit. That doesn't mean topic. You guys, you can take a contracts class on the RE forms. You can take 33 hours of contracts class on the RE forms, and we'll get credit for each and every one, as long as the course number is a different course number. And then you must also have 3 hours of CE. No recruiting for employment opportunities for any real estate brokerage firm is allowed in the class or on school premises. Report promptly any effort to recruit on behalf of other brokerages to myself, Dana, at MaximumOne.realty.com. There is my phone number. I am the director, or Heidi Kelly is the coordinator of the academy. And her email is rosterceadmin@eagentweb.com with her phone number. CE credits will be recorded within 1 to 7 business days. All right. And again, I see a question. I will email you. You do not need handouts for the class, but I will be sending you guys an email either today or tomorrow with copies of the handouts. So we are just going to dive in. The RE forms, again, a lot of people refer to them as the FMLS forms. They were born, and you see that I do have that in actual quotation marks rather than air quotes, as we do when we speak, and copyrighted in 2012. There were major revisions done in August of 2014 and 2015. One of those major revisions was they separated out the purchase and sale contract itself from the standard terms. And as we go through class, you'll see what the difference is, and not sure why they separated it out. I've got an idea, and I'll share that with you. Basically, they were born in 2012 because GAR, the Georgia Association of Realtors contract forms, those forms that are copyrighted and licensed by the Georgia Association of Realtors, were predominantly the main forms that all agents in Georgia, definitely Metro Georgia, I believe it was other places, but I can't speak to other areas. I have only been practicing in the Metro Atlanta area for 27 years, so I'm not quite sure what other parts of the state, what forms they were using, but GAR is a state entity. The majority of agents have readily available access to the GAR forms. After the market cycle of 2008, there were a lot of changes that went on, and GAR started charging for those forms. Either they charged by if you were a realtor, if you were a member of a local board of realtors, then part of your dues money also went to the Georgia Association of Realtors. So they got paid for your and authorized you to use their forms for that year. If you were not a member of a board, then you also were not a member of GAR. And GAR said, you are more than welcome to use our forms, but you need to now pay for the license, for the authorization or the licensing agreement to use those forms for that year. So there were a lot of brokers, and they made that announcement in the fall of 2011. So a lot of brokers who did not belong to any association of realtors, hence their agents did not belong to any local board of realtors or GAR, there was a big need for some sort of real estate contract forms that their agents could initiate and offer, counteroffer, exhibits, amendments, so forth and so on, to help their clients that did not have any cost. So that was what was responsible for the birth of the RE forms. And there were a lot of brokers involved. FMLS and Georgia MLS jointly were involved as well. And the first set of forms came out in 2012, and major revisions, 2014 is when they separated everything out. 2015, they made additional major revisions, because who can tell me what got it was actually enacted prior, but what became active October of 2015 that caused a major revision, not only in the RE forms contract package, but also in the GAR forms? Who's been practicing long enough and who remembers what happened that affected the real estate industry nationwide October 2015? You guys remember?
Was that the consumer rights thing where you had to have 3 days?
Yes, you are on the right track. And you guys, please answer in your chat so we can demonstrate that you guys are participating, because we do keep a chat log. But yes, you are exactly right. The TRID laws became enforceable in October of 2015, which was part of the Consumer Rights CFPB, Consumer Federal Protection Board is the overseeing government body that does that. But TRID stands for Truth in Lending, RESPA Integrated Disclosures. And basically at that point, there's a lot involved in the TRID federal regulations. But one of the things that happened, part of that was that it became against federal regulation for a lender and a closing attorney to close a transaction if the borrower had not been received in writing a disclosure of the lender fees. Now, it's not all the lender fees. You guys all know closings get changed. And if closing dates get changed, then cash to close for a buyer changes, because everything is prorated to the day of closing. However, there are certain lender fees that may not change. That basically the origination fee, and there are other fees that may not change after a certain point. So part of the TRID laws was the lender had to send out in writing a disclosure to the borrower of these fees once they were set in stone. Again, not cash to close, but other fees 3 days prior to closing, or they were federally prohibited from closing. So the contract forms had to account for that, because our contract forms are just individual contracts between buyers and sellers, and they do reflect a ton of license law for agents here in Georgia. But nevertheless, they are state contracts, individual contracts. And so they did have to reflect these federal regulations, which take precedence over any state contract, because it's federal. So all of the contracts, those changes, there was a lot of changes that went into place in 2015. And you'll see as we go through the RE forms, how the contract forms account for a lender not necessarily having sent out the TRID disclosures 3 days prior to closing. And the RE forms committee is continually adding forms to their library. So some of the forms, if it was an original form that has never been changed, the copyright date at the bottom will still say 2012. If it was a form that was revised in 2014, it will say 2014 or 2015. There are some revisions that have done since that time frame. So the RE forms, the actual individual forms, will have different copyright dates at the bottoms of those forms. The reason is that was the last time it was revised. Now, GAR, the Georgia Association of Realtors, part of their copyright licensing agreement is that an agent using their forms are required to use the latest version of those forms. And GAR comes out with revised forms every calendar year, and then they do a revision mid-year. So GAR forms now that any agent should be using per GAR's copyright licensing agreement will have at the bottom 2022. Now it's either going to have January 2022, or I believe the forms this year came out May 2022. If a GAR form has a date on there that's earlier, that is a GAR licensing violation. But the RE forms will have a whole slew of different dates on there. One other thing in general, the RE forms have teensy check boxes. You as an agent, you have got to be extremely careful and make sure that those boxes are checked, or that provision is not part of the contract, even if something is filled in. And you'll see what I mean as I get to the forms. And this is just what it says in the standard terms. This contingency option shall only be granted if the appropriate box related thereto is checked within the body of the contract and is thereby selected by the parties. If this contingency is not selected, this section shall not be deemed part of the contract. And you'll see what I mean as I get a little bit further on. There is a fabulous index of all the forms available to you by category, and it is form RE4, and it is divided by category. So you'll see there are all the agency documents, all the disclosure documents. I will tell you guys, whatever contract package you are using, even if you are using a HUD contract, an attorney written contract, new construction contract, so forth and so on, you have access to consumer brochures through the RE forms, which are free to agents in Georgia. Or if you are paying GAR, Georgia Association of Realtors also has several consumer forms. Can you mix and match the forms? Joseph, I'm going to answer that a little bit later on as we get into the contracts. But for the disclosures, for the consumer brochures, absolutely, that's not part of a contract. That is just a disclosure and consumer information to send to your public person with whom you are working. So yes, absolutely, I encourage you guys. That's not, again, these consumer brochures are not part of a contract. For example, new construction disclosure statement. If you've got a buyer buying new construction, and let's say they are signing a new construction form that is authored by, let's say, the Atlanta Builders Association, that's not a GAR form and that's not an RE form. However, I highly encourage you to go into RE or GAR if you have access to GAR and pull out this new construction disclosure statement and send it to your buyer. Again, it's not part of the contract. The builder seller doesn't have to sign it, doesn't need to be referenced as an exhibit, but you guys are all independent contractors and you need to protect your license, number one. And number two, not necessarily in that order, you need to protect the buyer, the consumer. and give them some idea of what they are entering into when they choose to sign a contract for new construction. Multifamily disclosure, developed lots disclosure, undeveloped landlord disclosure statement. That's if you're working with the landlord and there's a tenant. Disclosure of information on lead-based paint, the lead-based paint pamphlet. You can also get those at epa.gov. A guide to mold and moisture. If you are working in DeKalb County has their own plumbing disclosure exhibit. Here's a guide to radon. Here are some generic forms. Home selling, the process. Home buying, the process. Renting property, the process. Transactions involving out-of-state residents. I suggest, point of practice to you as an agent, whenever you are working with a buyer, you should include this consumer disclosure, consumer brochure, home buying, the process in every single one of your buyer packets, and go over that with your buyers at your initial buyer meeting. If you're working with a seller, you would want to include home selling, the process, as part of your listing kit, and make sure that they read through that as when they are signing a listing agreement. Then continuing on with the index by category, the RE forms has several sale documents, financing and contingency documents, and miscellaneous documents. So you will see the form number that is attached to the actual form name. You have access to this index, it's RE4, wherever you go in and get your contract forms, whether that be through Remind Docs Plus on FMLS or through Transaction Desk on Georgia MLS. If you are with a brokerage that supplies your contracts through .loop, if your broker has not uploaded the RE Forms contract package in your .loop, you still can just go to Georgia MLS, log into Georgia MLS outside of .loop, log into Georgia MLS, and go to Transaction Desk, log into FMLS outside of .loop, and look at the Remind Docs Plus, and you will see these packages where you can get these forms. All right. Oops, went too fast. Additionally, there are trust fund and termination documents. Now, one of the things that you will notice is the RE forms are generic, or not generic, they are multi-use. So what do I mean by that? Well, the GAR forms have been in existence for a very long time. The RE forms, as I mentioned, were only born in 2012. So there are very specific forms in the GAR contract package, and the way the RE package handles it is multi-use forms. And you'll see what I mean when we go through. Like, for example, for an amendment, GAR has a slew of different amendments for specific situations. Amendment to the sale price, amendment to change closing and possession date, so forth and so on. The RE forms will just have a general amendment, and it has a place where you indicate, are you amending a brokerage agreement? Are you amending a purchase and sale agreement? Are you amending a lease? So it says what type of transaction you are amending, and then it just has a a blank space for you to fill in the actual terms of the amendment. But again, you'll see more, but the RE forms have fewer specific documents, and they are more multi-use. As I mentioned, in 2014, the RE forms, it used to be one contract, just like GAR, where you had the actual fill in the blanks and the quote unquote legalese, or all the responsibilities of the buyers and sellers to fulfill what they said they were going to do in the fill in the blanks, and the consequences for what happens if they choose to not fulfill those responsibilities, or the legalese that goes with what they say they are doing. Then they separated that out and created a completely separate document. So now we have two documents. One is the contract, which is RE 100, and that is the basic terms of transfer of property between the buyer and the seller. It is 5 pages long. It does include several contingencies, and you guys are going to be excited when you see what contingencies are included in the actual purchase and sale agreement itself. The contract references the standard terms, but the standard terms are, as I mentioned, the legalese or the promises between the parties. The standard terms is a separate document. It's RE1. It is 9 pages in total. Point of practice, and you guys are going to see, I am going to try and hammer this home with you all throughout this class. Even though the purchase and sale agreement or the contract references the standard terms, point of practice to protect your clients and protect you guys. Please, 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 when you are printing out your contract, please print out the standard terms as well. Reference them as an exhibit and include them with the contract. You will see why as we go through class. So let me just show you what I mean. This is the actual, let me make this a little bit bigger for y'all so y'all can see it. This is the actual contract for purchase and sale of residential real property. And you have the name, we're going to go through this more in depth, but we've got the buyer and seller names, so forth and so on. But here in all caps and bold, right after you have the offer date and the buyer and the seller names. And it states, for the consideration of the mutual promises contained herein, you have this contract incorporates by reference those certain quote, what's not in quotes, standard terms for the purchase and sale of Georgia real property published by Orthros Real Estate Enterprises, LLC at, and here's a public public URL, public website anybody can access, www.reformsga.com. And in effect, as of the offer date, the standard terms, which standard terms shall become part hereof by reference thereto, very legal, right? Each party by affixing his or signature expressly agrees that he or she has read the standard terms and that it is his or her intent that the standard terms shall be incorporated in part of the contract. What is all the, and then you'll see at the very last page before the signature of the contract itself, only a 5-page contract, right before buyer and seller sign, there's a fill in the blank for initials. And it says, by initialing here, the parties acknowledge their receipt of a printed copy of standard terms. Failure to initial this section shall indicate that the parties, buyer and seller, have declined to print a copy and hereby acknowledge the sufficiency of the online copy of the standard terms. What does all that mean? This, in all bold in caps, means that when your buyers and sellers sign this contract, they are saying, I have gone online, I've pulled out my computer, I've opened up a web browser, I've gone to www.reformsga.com, I've read the standard terms, I understand the standard terms, and I agree that they are part of the contract. Now, we have access to the standard terms, again, in your MLS systems. Here is what the standard terms are. They are, again, multi-use, and it is a 9-page document, and it says there's not a place on the standard term document in and of itself for your buyers and sellers to initial, because it is referenced in the contract that they initial and sign, saying this is part of it. This says standard terms for purchase and sale of Georgia real property. These standard terms are part of the contract. You'll see this is where all the legalese is, and this you'll see how important this information is. Again, it is a 13-page document that is the consideration, the legal term. This is the promises that the buyers and sellers make to each other. This is what happens if they don't fulfill those promises. These are legal consequences, financial consequences, so forth and so on. So this information is extremely important. So again, point of practice. I encourage you to please print out these standard terms in the contract in and of itself. One of these fill in the blanks. I ask you to mark that checkbox and write in here standard terms and put a check in that box and actually reference them as an exhibit, so that when your buyer and seller say, well, yeah, I signed it. I said I went online and looked, but I didn't, or I didn't understand it. You can demonstrate, should you have to demonstrate to a broker, to a judge, to GREC, to an ethics board, to what's it called? Not court. Arbitrator, if you're in arbitration, you can demonstrate that, yes, you did actually go above and beyond. And regardless of the public saying that they agreed to do this, you went and did them a favor by pulling them out and referencing them as an exhibit and attaching them to the contract. Again, you guys are going to see why that's so important. All right. Here we go. All right, so this is what it says. We've just gone over that. All right, so moving along. And again, I'll point out the importance of that continually throughout the class. And I hope I will make my case by the end of the class. So then you have a property description and you have the property address and a legal description. So in Georgia, at least in Metro Atlanta, how many, this is rhetorical, you guys don't need to type in the chat. How many Peachtree roads are there? More than one. Therefore, what is the possibility that there is more than one 123 Peachtree Road? A good possibility. So just to make sure that the buyer and seller, and more importantly, the closing attorney and the deeds know what parcel of property is actually being conveyed, you need a legal description in addition to a property address. A legal description, the best legal description would be the legal description as referenced, a copy of that seller's actual warranty deed when this for the property that the seller is paying. Because in the warranty deed, it references the legal description. So that would be what I would attach when it says exhibit attached. There is a place where you can fill in deed book and page of whatever county. This would be the second best legal description because you are referencing the warranty deed book, not the plat deed book, but the warranty deed book and page. Therefore, anybody can go either online or go down to the courthouse of that county and pull out that book, open up that book, look at that page number, and there is recorded the warranty deed where you can see the legal description. This last option for a legal description references land lot district section, GMD. Here's a pop quiz. What does GMD stand for? Lot block. I'm going to continue on and give you guys some time to fill that one in. What does GMD stand for? Lot, block, unit, phase, section, subdivision of whatever county, including the plat book and page. The problem that a lot of agents have is they don't have all of this complete information. So you'll fill in the land lot and the district and the subdivision, but that's all you'll have. That is not necessarily enough identifiable information to parcel out, pun intended, what discrete parcel of land the seller is selling to the buyer. So unless you can fill out every single one of these, close Angela, every single one of these, I would suggest you either get a copy of the seller's warranty deed and attach it as an exhibit, or find the warranty deed book and page and the county. Now it's very helpful to put in the subdivision, but again, your closing attorneys are going to need a full legal description. And hopefully they are going to find one in their title search. But it's just, Georgia is one of the original 13 colonies. Therefore, there are lots and lots and lots of claims to the land here in Georgia. And a lot of the land has been divided and subdivided throughout these 200 plus years. So a legal description is very important. So yes, Penny, you are closer. GMD stands for Georgia Militia District. So not general, but you're very close, but Georgia Militia District. That was an old way. Again, as I mentioned, Georgia is one of the original 13 colonies. That is back in my day, that was one of the ways that different parcels of land were described. All right, then we're going on to, for the purchase price. And anytime the RE forms references amounts paid by the buyer and the seller, they put so that there's no opportunity for confusion or error. They put in that information in words and numerals. So whenever in a contract you see a fill in the blank, it calls for words. If you see a fill in the blank that is preceded by a $sign, it calls for numerals. So remember when we used to write checks? Some of you on this may not remember that, but some of you do. You used to write checks, and in this for the purchase price, for closing costs, so forth and so on, you are going to write it out in words and numbers so that there's no discrepancy. Now, just a note on this. Nowadays, how agents write contracts, there is a lot less of a chance for error because the majority of contracts are now and offers are now written electronically. You guys are doing these on your computer, on a desktop computer, on a laptop, on a tablet, on a phone. You're doing them electronically. So don't get me wrong. There is still an opportunity for a mistake, but we used to write contracts. Here's back in the day again. Gosh, I'm making myself sound really, really old. Back in the day, we used to bring blank contracts with us when we worked with buyers and showed buyers. And once we found the property they were going to write the offer on, we would either, if the property was vacant, we'd kind of stay there at the property, or we would go to a coffee shop or a restaurant, or even go to a parking lot, and the hood of the car, we would pull out a blank contract and fill it in with pen, with ink. So sometimes if you're writing it, and nowadays we still have some agents that are handwriting contracts, and you have to be careful. People's handwriting is kind of not legible. And sometimes a 7 can look like a 1. And sometimes people will put the little hash mark in a 7 or a 1 as to indicate if it's a 7 or a 1. Sometimes a very curly Q5. Is the numeral a 5 or is it an 8? Or is it a 2 or a 5? There's lots of, is it a 3 or an 8? So to avoid any confusion or error, the RE forms has a place to fill in the blank with words and numbers. If there is ever a discrepancy between the words and the numbers, the words take precedence. Same thing for earnest money, a good faith deposit of, and you spell out the dollar amount, and then you put it in numerals. Shall be payable to, and this is really teeny tiny. Here's where you're going to put in the name of the holder who is holding the earnest money. In the RE forms contract package, they call the holder the escrow agent. And then you fill in, you check the box. Is it a check, certified funds, money order, or cash? Do not deal with cash. 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 There is no way to protect yourself from an unscrupulous public person, and there is no way a public person can protect themselves from an unscrupulous agent or broker. What do I mean by that? Well, let's say the buyer says, let's say the buyer gives you $3,000 cash for earnest money. Then they terminate the contract, and the escrow agent releases $3,000 back to the buyer. The buyer says, I didn't give you $3,000. I gave you $5,000. And you're like, no, you only gave me 3,000. They're like, no, I gave you 5,000. There is no way to prove the amount of earnest money. You've got signatures on contracts, so forth and so on. So you could have a buyer that's trying to swindle a broker, the holder of the earnest money, the escrow agent, out of $2,000 additional dollars. Or you could have an unscrupulous broker or agent, and the buyer could actually have given you 5,000 and you only marked 3,000 in the contract, and it just didn't get noticed. Terminate, send back 3,000, and the buyer says, I gave you 5,000 and you only refunded 3,000, when in essence they did give 5,000. So cash is very, very difficult to prove. You can't make it, you don't even think about putting cash on a copy machine and making a copy of it. You could get a knock on the door for potential counterfeiting. Number one. Number two, a lot of copy machines nowadays won't even make copies of cash. And once that cash is deposited, we don't return the actual dollar bills with those serial numbers back to the buyer. So bottom line, don't deal with cash. Additionally, for, let me see if I have this in here. Additionally, for check, if you are dealing with personal checks, you need to check with the escrow agent on their policies regarding when funds from a personal check are available. Many brokerages will not make those funds available for 10 banking days. Well, if you've got a quick closing, or if you have a buyer that terminates prior to those 10 banking days and they want their earnest money back, or they go under offer for another contract, seller number two is also going to want earnest money. You cannot contractually use earnest money on one contract for another contract if it is not available, meaning the holder has not yet made those funds available. And it's not just the escrow agent. There is Georgia license law that says the holder of earnest money does not have to act on those funds until they are sure that they are quote unquote good funds. In other words, funds have cleared the bank. So a lot of holders will have policies on the acceptance of personal checks. Additionally, they won't accept personal checks over a certain dollar amount, and over $10,000, I highly encourage you guys to deal with wires. So best source of funds that's trackable and more readily available should a contract terminate would be certified funds. If the earnest money is over $10,000, I absolutely highly encourage that you guys do that by wire. Why do you say that, Dana? Well, the IRS, from the Homeland Security Act, there is a form 8300 that the IRS requires that a holder complete, and it has all sorts of buyer identifiable information. We need buyer's name, address, license number, or passport, and we have to report that to the IRS per the Homeland Security Act. If it's a wire, we do not have to do that because the banks have all that information. So again, highly encourage you guys to deal with certified funds. Definitely if it's over $5,000 certified funds, over $10,000 wire. Okay, the question is, yes, Penny, I will email you guys copies of all the handouts, a PDF of the slides, as well as all of my markings with these handouts with all of my underlines and arrows and highlights. So I'm going to email that to you guys after class. It might be a couple days, but it'll be by Friday. Additionally, oh, can you do Cash App to a broker? Derek, great question. I highly discourage that. Again, that is not easily trackable, traceable. We are relying on a third party to try and get access to that. Nothing's an issue until it is an issue. And if it's an issue, it revolves money and it revolves around proving Was the money sent? Was the money deposited? Was the money credited to Bitcoin? I don't know about other brokers. You need to check with the brokerage or the closing attorney, whomever is the holder. We absolutely do not accept Bitcoin. We accept personal checks, money orders, certified checks, and wires. We do not even accept ACHs. The majority of brokers and closing attorneys in Metro Atlanta do not accept ACHs. No Zelle, no Cash App, no electronic, no PayPal. You guys have got to track money, because guess what? If something falls apart, guess who that public person is going to come for looking for that money? You. So do you want to be able to prove it? I would think so. A copy of a certified check, a wire, those are definitely more readily available, easily accessible between the holder and the banks and you. You don't have to go to, how many times have you guys tried to get in touch with, I don't know, PayPal, Cash App, Zelle, Facebook, and they go down all the time. You can't ever find a person to talk to. When you have to give somebody back several $1,000s and you're going to be sued for it, do you want to rely on a somebody you can't even talk to prove that it was done? Nope. Do you accept ex-spouses? I don't know. It depends on what the amount of the earnest money is. All right. So going on to the payment of the earnest money, again, teeny tiny boxes. This first option says the buyer has already remitted the earnest money. In other words, the buyer has already sent the earnest money as of the time they write the offer. And pre-printed in here is that the holder, the escrow agent, shall deposit that within 3 banking days. Remit is just a fancy word for send. Option 2 is the buyer, when they sign the offer, have not yet sent the earnest money, but they will within a certain number of days from the acceptance of this contract, which is the same concept as a binding agreement date. So the time frame within which a buyer is obligated to send this good faith money to the holder is negotiated between the buyer and the seller. However, pre-printed is once the holder, the escrow agent, is in receipt, we have 3 banking days to make that deposit. Now, let's look at this last sentence. I'm in the earnest money paragraph of the actual offer, purchase and sale agreement. And it says, date of deposit. In the event said payment is not timely remitted, seller shall be promptly notified by the escrow agent, and seller shall have the rights and remedies set out in this section. This is paragraph 3.1 of the contract. So this means the buyer never sent the earnest money, or they sent the earnest money, the holder deposited it, and it was not honored by the bank. But for whatever reason, those funds are not on credit with the holder in their bank account. So the holder, the escrow agent, then must send notice to the buyer and seller, especially the seller, saying, look, this buyer said they were going to send you earnest money in good faith for you accepting their contract. They didn't do it. You now have these rights and remedies set out in this section. We go to the next section. Closing. What does that mean? So let me show you guys what this actually looks like. Let me turn my volume. Let me show you what this actually looks like in the contract itself. So here's the contract. We're at the very bottom of page 1. Here's where we just went over. Earnest money, here's the amount in words, dollars, payable to, that's the escrow agent, check, certified funds, money order, blah, blah, blah. Either the buyer already has sent it to the escrow agent or they haven't negotiated. Very bottom of this page, page 1 of 5. Seller shall have the rights and remedies set out in this section. We go to top of page 2, closing. Don't you think a seller is going to want to know what their recourse is if the buyer has just defaulted by not sending the earnest money? Yeah, if I'm a seller, I'm going to want to know What are you going to tell them if you're an agent presenting this offer to a seller and the seller says, well, what are my rights and remedies? Where do you think that stuff is all, where do you think the seller's rights and remedies are fully explained? Heidi got the correct answer. Yes, in the standard terms. So this is point number one, why I implore you, I beg you guys to please print out this document and reference it as an exhibit and attach it. So here's the property description, blah, blah, blah. Here in the standard terms, which is a completely separate document. Again, the contract is RE 100. The standard terms is RE1. Here in the corresponding paragraph, paragraph 3, earnest money, buyer's failure to remit, again, remit is just a fancy word for send, to fail to send the earnest money. And again, even if they send it, so it says regardless if the payment was sent prior to acceptance or on a specific date, or if the method of presentation is not honored by the bank. So even the buyer sent it, but the funds weren't there. The escrow agent does not have those funds in their bank account. The escrow agent shall promptly notify buyer and seller. The amount of the agreed upon earnest money deposit shall be paid by certified check or other collected funds within 3 days of the notice. Seller shall have the rights and remedies set out in the contract. Notwithstanding the above, in the event the earnest money is not remitted to the escrow agent as set on the contract, earnest money is no longer part of the contract, and seller may, here's what the seller can do, unilaterally terminate the contract within 7 days of receipt of the notice, or if the seller holds the earnest money, which typically is in a new construction contract. Remember, I told you these are multi-use. The standard terms are multi-use as well. Or demand full performance of all other terms of the contract and proceed to closing. So what does all this mean? All of this means, so basically what happens, a buyer doesn't send the earnest money or it's not honored by the bank. The escrow agent then sends notice. So there's a default that constitutes a buyer default. Buyer said they were going to do it, they didn't do it, that's a default. The holder then sends notice to the buyer and seller saying, look, the buyer has defaulted on the contract. You have to send notice to the parties. Then the party that defaulted has the opportunity to what we call cure the default. They have 3 days to make good on the earnest money. If they don't do that, the seller can say, okay, you really don't want my property. I don't believe that you are honoring this contract in good faith. I am going to terminate the contract and go on and sell it to another buyer. Or the seller can say, you know what, that's fine. There's no earnest money in the deal. We're going to go to closing, but that amount of earnest money is just going to be additional cash that you're going to have to bring at closing. Why on earth would a seller do that? Well, there are many sellers that do that. If it is a quick closing, if it is an all cash transaction, if we're closing within a week or something like that, or if it's an investor deal, a seller will say, look, no problem. I'll keep my house off the market for a week. I understand you didn't have the earnest money because you were getting it out of this account or that account. I'll take my chances. I'll keep my property off the market for a week, go to closing. If we don't close, however, there's no earnest money in the deal. If we do close, that's just added money you'll have to bring to closing. So Heidi brings up the question, great question. What is the procedure for the attorney holding the earnest money? So let's go through that while we are here, because there are several buyers and sellers who opt for whatever reason to have a closing attorney as the escrow agent rather than a broker. So again, we put in who the holder is. Now, I'm back on the contract. I'm making y'all dizzy by scrolling so fast, so I apologize for that. I'm on the signature page of the contract. We've got a place for the buyer to sign. We've got a place for the seller to sign. We have a place for the buyer's broker to sign. We have a place for the seller's broker to sign. Where do you see a place for a closing attorney to sign the contract? The answer is nowhere. There is nowhere for a closing attorney to sign the contract. Now, back in the standard terms, here where we talk about earnest money, disbursement of earnest money if held by an escrow agent. So first of all, the escrow agent is already charged. Part of the duties of the escrow agent, escrow is just a fancy word for trust or holder of the earnest money, so forth and so on. So the escrow agent, the holder, first of all, the first thing they have to do is deposit the earnest money. If they don't deposit the earnest money, and they were charged with doing that back here on the contract under the earnest money, it said escrow agent shall deposit. So the first thing the escrow agent has to do is deposit. The second thing the escrow agent has to do is if we don't get the earnest money, we have to send notice. If we do have that and there's not an issue with the earnest money, but for whatever reason it doesn't close, we have to do a 10-day letter. We have to interpret the contract if we don't get agreement by the buyer and the seller to disperse the earnest money. One of the things is we have to interpret the contract, send notice how we're going to disperse the earnest money. Or if it's too much money or it's too complicated an issue, we have to file for a lawsuit in court and interplead. It's called interpleading the earnest money and let a judge decide. If everything goes through as normal, then we take the earnest money and we transfer it from our trust account to our operating account. The buyer gets credit for it at the closing and we use it as funds. So there are a lot of things that the escrow agent is responsible for doing with respect to a contract, specifically with respect to earnest money. So the broker doesn't sign either. However, we did say here is a place for the buyer's broker, seller's broker to sign. That is the agent's signature. When you guys are agents, you are affiliated licensees. Affiliated with whom? You are affiliated with your broker. All contracts are done in the name of the broker, whether that be a purchase and sale agreement, a listing agreement, a buyer brokerage agreement. Everything is done in the name of the broker. All commission is broker commission, is earned in the name of the broker. Then the broker pays you, the affiliated licensee, by virtue of our independent contractor agreement. Also, in your independent contractor agreement with a broker, the broker gives you permission to sign contracts on their behalf and in their name. So it specifically says buyer's broker, seller's broker, has the name of the brokerage, but it has your name, your signature. It has the broker's license number, which typically means the firm's license number, not the actual qualifying broker, but the firm's license number is registered with GREC, and your license number. So when you are an agent and you sign up with a broker, the broker gives you permission to sign contracts in their name. Your signature on a contract in Georgia basically says that if the broker is it is elected as the holder of the earnest money, that I agree, I give you permission to engage me into the to fulfill the responsibilities with that earnest money, everything that entails with respect to the contract and license law, because your brokers are all real estate licensees, and I am beholden to license law as well, and my firm is also beholden to license law. So if I do something that is illegal, or even not illegal, but against what the contract says, then my license can be, my personal license, real estate license can be in jeopardy, and my firm's real estate license can be in jeopardy. A closing attorney, they can't do anything, they can't steal anybody's money, but there's no repercussions for them per license law. They're not going to lose their attorney's license. not only does your agent's signature engage the broker to fulfill the responsibilities as the escrow agent, but also there is a section here under brokerage where you indicate if we are working with, if your broker is working with the buyer as a client or the seller as a client, when you sign, you are saying that the broker agrees that I do have a client relationship. It affirms the client relationship per Beretta laws, which is spelled out here, OCGA 10-6A-1. Those are our brokerage relationship and real estate transaction or Beretta laws. This affirms that yes, the buyer has signed a buyer brokerage agreement or the seller has signed a seller brokerage agreement. Again, back to what is the issue if the closing attorney is holding the earnest money? Well, in essence, you guys, I'm going to stop the share for a second. In essence, what's happening is your buyers are handing your closing attorneys checks for thousands and thousands of dollars with no strings attached. There is nothing signed. There is nothing the closing attorney agrees to do with that money. They don't agree to make the deposit. They don't agree to send notice if the buyer never sent it. They never agree to disperse the earnest money in any particular way if there's a dispute or a discrepancy. And we've had a lot of closing attorneys that have been the holder of the earnest money. And even we had one back several years ago where there was a termination and release agreement. The buyer clearly defaulted. The buyer signed a TNR requesting that, and the closing attorney was holding it, requesting the closing attorney disperse the earnest money to the seller as liquidated damages because they did not want to get sued by the seller or the brokers. The closing attorney wrote the check back to the buyer. And we said, well, you were directed by the buyer to send it to the seller. Closing attorney said, I'm not a party to the contract. I didn't sign any agreements with respect to these funds at all. I got a check from the buyer. I'm sending it back to the buyer. Y'all can handle that. Buyer and seller can handle that outside of me. I have nothing to do with it. If you are an agent using the GAR forms, GAR has separate forms where the closing attorney does in fact sign a document agreeing to fulfill all the responsibilities as the escrow agent, as the holder of the earnest money, including notices, dispersing it, so forth and so on. There is not a form in the RE forms. I'm going to show you how to handle that in a minute. Okay, so let me look at these questions. So on the RE form, if the broker is the earnest money holder and there's a dispute about the release, a judge has to make the determination. No. The broker in the RE forms, just like on the GAR forms, let me go back to the slideshow. Let me go back to share screen in the slideshow. Hang on. It says if there, okay, it's in the RE forms. It says if there is a dispute over the earnest money. So basically if the holder, the escrow agent, can disperse the earnest money pursuant to a separate written agreement by the parties agreeing. That's the TNR, and or disperse upon if we get a court order or an arbitrator. But it says if the escrow agent has, if the closing has failed to occur no more than 30 days after the notice has been received, meaning notice that we're not closing, the escrow agent shall notify the parties of the escrow agent's disbursement decision. Upon, let me see, say it further up here. Upon receipt of escrow's notification of disbursement, parties shall have 10 days to object to the disbursement if we change our mind, so forth and so on. So we can do, it's still the quote unquote 10-day letter. The broker who's holding the earnest money, if we don't get a signed agreement to release the funds, we still have the contractual opportunity and we are directed by the contract to go through and make an interpretation of the contract, figure out who terminated. Did they terminate by an unexpired contingency? Did they terminate by default? What did the parties agree to? And disperse the earnest money and still send out the 10-day letter. That is the same in the RE forms as in the GAR forms. It goes on to say, in addition, if the earnest money is in dispute, the escrow agent may file an action to interplead the earnest money and allow a court to decide. That's also in the GAR forms. If the termination was too legally complicated, or if it's too much money, that is the exact same in the GAR and the RE forms. The holder does not have to do the 10-day letter. We can let a judge decide. So Rachel, that's the same in both contracts. Angelique, I am teaching this class generically. So the question is, does a broker prefer GAR or RE? That is a question to ask your broker. I will tell you that the decision is your client's decision. Your responsibility as an agent is to be well-versed in the contract forms that you are helping and going through and explaining to your clients. It is their decision whether or not one is in their better interest or not. I have a pop quiz question at the end of class that I'll ask you about the contracts. So you as an agent, you really need to be familiar with the RE forms and the GAR forms so you can help your client make that decision as to which one best reflects their interest. I will also tell you that license law says you must present all offers, period, regardless of who copyrighted the form. If it's on a GAR form, if it's on an RE form, if it's on a HUD form, if it's on an attorney written form, if it's on a new construction form, if it's on a notebook paper, if it's written, if they got something online, you still must present all written offers. And a broker may not have a policy against their clients accepting an offer regardless of the form it's on. Now, your broker may have a policy on a form that you as an agent should initiate an offer on, but be very careful with how you interpret what your brokers are saying. Because if your brokers are saying, we only accept GAR forms, I would ask you to explore that statement with your broker a little more in depth, because I would blatantly say, number one, that's a violation of license law, because you have to present all offers regardless of the form that it's on. And it's up to the client to accept the form or not accept the form. The client is the party that is selling the property. And if that were true, if a broker does say we only quote unquote accept GAR forms, that means that agents in that brokerage cannot deal with a lot of new construction, because new construction contracts aren't all GAR contracts. Can't help buyers with HUD forms, Fannie Mae, Freddie Mac, investor, attorney written forms. So you need to explore that conversation with your broker regarding that. Again, as I said, there can perhaps be a policy where you as an agent they may specify a form to initiate an offer on. But again, I would even explore that a little bit more in depth regarding that means you can't help your buyers with new construction unless that new construction builder is using a GAR form. So which is stronger? Again, there are different parts of the different contracts, and it would depend, it would have to reflect what your client's best interests are. The Georgia Real Estate Academy teaches another CE class called 2022 Contracts Review, and it is a direct head-to-head comparison and contrast of the RE forms versus the GAR forms. That, Angelique, is a 3-hour discussion. I will say that the GAR forms for agents that have been practicing for several years and for a lot of well-established brokers, there's a lot more familiarity with the GAR forms because they have been around for longer. But again, the GAR forms change every year as well. Broker doesn't accept RE forms. Okay, so let me answer that question in a minute, Sharon, but let's go back to the builder. So, I'm sorry, if the closing attorney is the holder of the escrow money. You guys, you're having your buyers give them a check for thousands of dollars, nothing in writing. Let me show you how you would handle that. Again, if you are in GAR, but this is not a GAR class, there is a specific form for that. If you are using the RE forms, I strongly suggest that you, what is my password? Sometimes these computers that save your password, sometimes that's a blessing. Sometimes if you're on a different computer, it's a little bit crazy. Here's how you get in the RE forms in FMLS. So you log into FMLS, you go to products, you're going to click on Remind Docs Plus. You can click over here to the Forms Library, Georgia. These are the GAR forms. This is Mid-Georgia MLS forms. There's also Alabama forms. These are the RE forms, and these are all the forms. You can always go up here and search. You click the little magnifying glass, and I'm going to put in escrow because here's what I want to show you. I have access to both the GAR package and the RE forms. So these are GAR forms. This is the RE form. If you are working on the RE forms, and for whatever reason, the buyer and seller negotiate to have a closing attorney as the holder of the earnest money, I highly suggest that you pull out this document, Escrow of Funds Agreement. You fill in all the information, and you have the buyer sign it, the seller sign it, and the escrow holder. Here is where you would have the closing attorney sign it. So at least you will have the closing attorney sign a document describing what they are going to do with that money. And again, it talks about that they have to deposit it. It talks about lender, the escrow. It talks about nothing's an issue till it's an issue. And it talks about how those funds get dispersed and the escrow holder's duties, disputes, so forth and so on. So again, if you are using the RE forms, there is not a specific document like this is escrow agreement, and it is RE 215. In the RE forms, they do have a specific agreement for the closing attorney to sign, but under the RE forms, that is what I would suggest. So let's go back here. All right, and a lot of agents, broker does not accept the RE forms, try to send a GAR form for all parties to sign. Okay, so Sharon, that does happen a lot, and that would be a buyer and a seller option. So just like any offer, if you get any offer, and like in this example, I'll say the buyer writes an offer to a seller, and the seller wants to make a change. Whether that change is something, one of the fill in the blanks, like the sale price or the closing costs or the closing date or any of the terms of the offer, a change of an offer includes not only the fill in the blanks, but you guys, an offer includes all of the pre-printed information in here as well. And so if a seller, you ask it in terms of a broker, again, your broker is not selling a property. If the seller doesn't want to accept the RE form, and the seller likes the pre-printed verbiage of a GAR form or any other form, then they can, what are they doing? They are making a counter offer back to the buyer. So rewriting or pulling out for you as the seller's agent, pulling out a blank GAR form and making a counter offer on the GAR form even if the fill in the blank information is the same, sale price, closing cost, closing date, blah, 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 it still constitutes a counter offer because the terms, the pre-printed terms of GAR versus RE are completely different. And I will point out some of those differences in a minute. So it just constitutes a counter offer. So my thought is, if the seller wants to make a counter offer back to the buyer, then the ball's in the buyer's court. The ball can either sign and send notice of agreement and you've got a binding contract, or the buyer can say, no, I like the terms, pre-printed terms of the RE forms, pull out an RE form, rewrite it back and send it back to the seller as a counter offer. Seller doesn't have to accept it. If they don't come to an agreement, then you have an offer that was never negotiated and the seller sells the house to somebody else. Yeah, I hear that you're saying your broker cannot make that decision. That's why I'm saying, I just said that earlier. That is you as an agent that must understand these contract forms, explain them to your client so your client can make the decision. Your broker can make that decision if your broker's selling property. Again, your broker can have a policy for an agent to initiate a contract on, but they can't demand, your brokers are not attorneys. They can't demand a seller or a buyer, they can't demand that a seller accepts a specific contract on a GAR form, or that a buyer accepts a specific contract on a GAR form. And like I said, if your broker is saying that, that's a license law violation. They can't, it's not them. The offer is not for them. It's not an offer. It's an offer for your seller to accept. All right, we've got to move on from that discussion. I've got some, you know what? I have some information that I will include in my handouts that references, where is it? It references all of the license laws regarding presentation of offers, as well as Realtor Code of Ethics. And that document should help you out, Sharon. So I will include that with all of you guys when I send out copies of my handouts. All right, let's move on. That was a pretty good discussion about earnest money, but it's really important because, again, nothing's an issue till it's an issue. But if a contract fails to close, money is what everybody wants. And typically in a purchase and sale agreement, the money that's up for grabs is the earnest money. I will, let me say one more thing before we leave the topic of earnest money. It is your responsibility as an agent, regardless if you are working with the buyer or working with the seller, to follow up with the earnest money, whomever the holder is. You on the buyer side, because you want to make sure your buyers are not defaulting on the contract, and on the seller side, because your seller has potential claims to that earnest money, as well as both of your brokers. You guys are responsible for following up with the holder, with the escrow agent. Did you receive the earnest money? Did you deposit the earnest money? Did you receive the earnest money? Did you deposit the earnest money? And you guys should be following up on both sides and making sure that that has been achieved. All right, we've got to move on. Closing. Again, there is a closing date. You fill in the date at the office of, this would be the closing attorney located at whatever, Georgia. This is just a little bit, there are some closing attorneys that have offices throughout all of Georgia. So this is just sort of as a customer service thing. Are we closing at their Marietta branch, at their Alpharetta branch, so forth and so on. What if the buyer says they sent the earnest money, but then you find out they didn't? What do? And then they can't get financed. Again, the holder needs to send notice. You need to check with the escrow agent. Did they get it? And if they didn't, the escrow agent needs to send notice to the buyer and the seller. The buyer has the opportunity to cure. If not, the seller can terminate. If the seller fails to terminate and the buyer can't get their financing, then you as the buyer's agent, you need to keep up with your financing contingency. Well, you would probably need to terminate under due diligence, because the buyer not having cash to close will not protect the earnest money, even under a financing contingency. So if that's the case, you would definitely need to keep up with that prior to the end. If it's past due diligence, your buyer's going to default. And if they never sent the earnest money, the remedy for default, if notice was sent and the seller didn't, if the seller's going to terminate, the seller terminates and there's no earnest money. If the seller doesn't terminate, because okay, let me go back to this one more thing. The earnest money has to be sent within so many days and then deposited within so many days thereafter. It is that's what I'm saying. You guys, you need to follow up with these escrow agents. Did they get it? Did they deposit it? And if not, did they send notice? If they send notice and the seller doesn't terminate and then the buyer defaults, then the buyer just defaults and there's no earnest money for the seller to get because the seller agreed to go on with the contract without earnest money in it. If the if the seller terminates because the buyer doesn't cure, then the seller will terminate and there's nothing. However, if nobody terminates, there's no earnest money, and the buyer then fails to close and defaults, there's no earnest money for the seller, but there is a section in the default section. The brokers can legally pursue that buyer for the commission they would have earned. I just sent out a notice today on a defaulting buyer for earnest money. They terminated 2 days prior to closing outside of all their contingencies. And we're sending a default letter to them requesting for the commission that they owed because that's in the contract. So it would constitute, Angela, it would constitute a buyer default. If it was past all that, there's no earnest money for the seller. The seller agreed to continue on with the contract. If the seller had terminated, then it's just a terminated deal. If it's past, if the seller didn't terminate, then the brokers can pursue the buyer for commission. All right. Now, then we have, if the closing attorney is unacceptable to a buyer's lender or title, moving back to closing, then blank, you guys need to fill in this blank. Don't leave any blanks in your contracts. You're going to fill in either buyer or seller shall have the right to select a different closing attorney. So it's make sure you negotiate that if the closing attorney represents the buyer's lender. If the buyer's lender doesn't accept that or approve of that, then buyer or seller shall have the right to select. Typically, we see buyer in there. And then we talk about possession shall be granted either at closing or so many days after closing at whatever time, or blank days before closing. If possession of the property is before, other than closing, either before or after, you need a separate occupancy agreement. You guys, there is a firm closing date. Please notice, it does not say on or before. It says the closing shall take place on. Firm closing, it must be specific and determinable. You cannot leave a party's interest in the property open-ended. You also cannot say on or before, because that does not demonstrate what we call a meeting of the minds. Meaning, and that's one of the elements for an enforceable contract for real property here in Georgia. Let me just give you an example. So you need to put in a firm closing date. If you're going to change that closing date, you need to do it by an amendment. There's no 8-day unilateral extension rights, and I'll show you that in a second. When it references can you close before if all parties agree? Yes, Angelique, and you're going to agree on an amendment. You're going to pull out an amendment and say all parties agree closing date shall be X versus Y, and they sign it, and that is agreement. You guys have got to do things in writing. Agent to agent emails are not enforceable upon your buyers and sellers, and phone conversations are not enforceable in court. You guys have got to do everything in writing on forms with buyer and seller signatures. Emails between buyers and sellers are not enforceable either. And then there's an occupancy agreement if the buyer is going to take occupancy anytime other than at closing. So let me go up here, because for whatever reason, we're starting to see on or before, like closing to be on or before October, let's just say on or before October 30th. So the seller gets everything done. They've got movers lined up. They've got a new house they're moving into. they're doing a back-to-back closing. So they're closing on their new house October 30th. They're closing on this house October 30th. They've got utilities all scheduled. They've got a moving truck lined up. Moving trucks are hard to get, especially at the end of the month. They've got all that stuff lined up. And your contract said to take place on or before October 30th. Then let's say the buyer says, hey, guess what, seller? Good news. The lender got it done earlier. And let me look here. The lender got it done earlier. So instead of closing on October, we can't close on October 30th. Instead of closing on October 28th, guess what? We're going to close. We've already scheduled it with the closing attorney. The lender's got the package done. We are going to close on Friday, October 14th. And the seller says, I don't agree to October 14th. I've got nowhere to go until the 28th. I've got everything set up, scheduled, lined up for October 28th. I don't agree to October 14th. And the buyer says, so sad, too bad. You already did, because in the contract we had on or before October 28th. Guess what? The 14th is before the 28th. Well, then you have a huge mess on your hands. So the contract does not say on or before. They took it out for a reason. You guys stop writing it in there. You're going to create problems for yourselves and for your clients. Okay. Now, let me talk about extension of closing. For any of you agents, let me go to here for a second. For any of you agents who are used to doing contracts or have seen or interacted with contracts on a GAR form, you are familiar with what they call the 8-day unilateral extension, meaning either party can extend the closing date. If you're binding under a GAR, Georgia Association of Realtors contract, either buyer or seller may extend the contract for 8 days unilaterally, meaning with one signature, the other party doesn't have to agree, but it's for very specific reasons. The lender didn't get the job done. The closing attorney hasn't finished the title search. There is a cloud on title. There are very, very, very specific reasons. It's not just because they need more time. That's not Georgia law. I've had some agents mistakenly think that is Georgia law. That is not Georgia law. That is just a contract provision specific to the Georgia Association of Realtors Purchase and Sale Agreement Form F201. It's not law. So there is no 8-day unilateral extension for parties that are binding under the RE forms, parties that are binding under new construction contract, parties binding under a HUD contract, parties binding under an attorney written contract, parties binding under an investor written contract, Fannie Mae, Freddie Mac. Has nothing to do with Georgia. That is a specific contract provision. However, remember what we talked about the TRID regulations? And we said that we said that a lender, if there is a lender involved, the lender is federally prohibited from closing a transaction with a public buyer if they have not sent out those TRID disclosures. Remember, we said that. So how does the RE forms handle that? That's one of the provisions under GAR. You can unilaterally extend it. How is that federal regulation handled in the RE forms? Well, that is all spelled out where? Yep, you guessed it. Here I am in the standard terms. It is spelled out under paragraph 6.3.2, talking about the lender, because this is a lender issue, because this is a lender federal guideline. And basically what it says, it's worded a little weird. So let me read it to you, and then let me tell you in practice how this works. It says, if this stands for Fannie Mae, Freddie Mac, FHA, USDA, or VA underwriting guidelines. In other words, basically, if there's a loan being done, it is going to fall under one of those underwriting guidelines. Mandate compliance with any underwriting criteria expressly contrary to the provisions of the contract, those provisions shall prevail and be binding upon the parties. However, if these guidelines, meaning these underwriting guidelines by these federal entities, result in an increase in cost or expense to the seller or affect the date of closing. So let's talk about this: increase in cost or expense to the seller. Let's say a buyer and a seller are under contract for conventional financing, which would be governed by Fannie Mae or Freddie Mac. And then the buyer changes to FHA or VA or USDA. Well, under those government insured loans, FHA, VA, USDA, there are certain costs a seller must pay that they are not required to pay under a conventional loan. So if that were the case, the seller does have the option to terminate the contract or affect the date of closing. If the lender has not sent out those, like you guys are saying, the 3-day TRID disclosures within 3 days prior to closing, that is going to affect the date of closing. Then the seller, at the seller's sole discretion, shall have the right to unilaterally terminate the contract. So it's not an extension of contract, it is a termination of this contract. Your buyer is going to be a little upset if the lender didn't get the job done, didn't send out those trade disclosures, and all of a sudden the seller says, well, guess what? I'm terminating. Go find another house. I'm going on to another buyer. The seller's sole discretion shall have the right to unilaterally terminate the contract within 3 days of seller's receipt of notice of the applicability of such guidelines. In such event, seller may terminate the contract by delivering written notice of termination. It releases buyer and seller from any further obligations. If the seller does not terminate the contract, seller is deemed to consent to those changes that are mandated by underwriting guidelines. So that's what those are the rights. But let me explain to you how this works. So basically what this means is the buyer, you as the buyer's agent, you find out the lender did not send the buyer those 3-day disclosures. So we can't close on our closing date of October 28th. The lender says, look, we can't close on October 28th because I didn't send them out. We're going to have to close on November. Let me look at the calendar. We're going to have to close on November 4th. The first thing that has to happen is the buyer must send the seller written notice that per underwriting guidelines, we cannot close on the contract closing date of October 28th. We need to close on November 4th. Now, I would probably do that in an amendment, and if the seller agrees to it and signs, then you have a new closing date. But the first thing that has to happen per this paragraph, the buyer needs to send the seller saying, look, per this paragraph, we cannot close. It's underwriting guidelines. We can't, there's something that's going to change the date of closing. We send notice. The seller then has 3 days from the date of that notice to say, yes, I agree, or no, I'm going to terminate the contract. Good luck. Sorry, you couldn't get your lender to get it done in time. I'm not waiting for you. I don't have to wait for you. I'm going on to another buyer. As a matter of fact, I've got a backup contract for $10,000 more. Have a nice day. So then the seller has 3 days. So first of all, the buyer has to send notice that we can't close on that date due to underwriting guidelines. We have to close on this date. The seller has 3 days to say, nope, terminating the contract. Seller terminates the contract, buyer gets the earnest money back, and seller goes and sells it to someone else. Buyer has to go find another house. Or if the seller says, okay, then if the seller does not send a notice of termination, then that means all parties agree the new closing date is whatever the date was in that notice. I suggest you get it cleaned up with an amendment. So back to the slideshow. That is how the RE forms deals with the TRID federal laws. So again, it's not an 8-day unilateral right to extend. It is a seller unilateral right to terminate, but all of those procedures must be followed. All right, I've got to talk a little faster, but I think we did have a good discussion on earnest money, and that's a huge important difference, especially if you as an agent are used to the provisions of the GAR contracts. That is another main difference between the two sets of forms. So a lot of sellers prefer the RE forms contract because they're not tied into a contract for 8 more days because the buyer didn't get the job done because the lender didn't get the job done. The lender that who chose? The buyer chose. Yeah, Penny, we're going to take a break in a minute. Let me get through just a little bit more and then we'll take a break. Closing costs. Now, this is a really nice thing. In the RE forms, the closing cost is expressed as a % of the sale price or a flat fee. It's really nice if you say that the seller shall contribute X% of the purchase price as closing costs to the buyer. The reason that's nice is if the buyer and the seller after the initial offer and counter offers counter and go back and renegotiate the sale price, the closing cost contribution will change by only having to counter the sale price because it's a % of the sale price. If you do it as a flat fee, then you're going to have to kind of do some calculations and calculate a change not only in sale price on a counter offer, but the closing costs as well. Now, there are 3 contingencies built into the purchase and sale agreement in the RE forms. The buyer's general right to terminate, which is the same concept as the due diligence, the appraisal contingency, and a financing contingency. If the parties go binding under the RE forms, you do not need any separate exhibits or documents for the buyer to be protected under an appraisal contingency or a financing contingency. But you must check the box. So, in other words, if you put buyer's general right to terminate, due diligence period, and let's say you fill in the blank here that says 7 days, if you don't check the box, there's no due diligence period. Appraisal contingency. If you do not check this box, there is no appraisal contingency. Financing contingency. If you do not check this box, it is not subject to financing. It is an all cash deal. Now, one more thing while we're here. Look what it says under financing contingency. In consideration of seller granting buyer's general right to terminate, buyer has paid non-refundable money. Sufficiency is hereby acknowledged. So many days after acceptance date. What is it? What are the termination rights? What happens to earnest money? Appraisal contingency. This contingency shall expire at 11:59 p.m. on the day that is blank number of days after the acceptance date. Well, what happens if it doesn't appraise for sale price? Financing contingency. This contingency shall expire at 11:59 p.m. on the day that is blank days after acceptance date. And then also the next section does have where you fill in the amount of how much are they financing, how many years, adjustable or fixed, so forth and so on. It does say, I will give you one caveat. If the buyer is getting an FHA or VA insured loan, you do need an FHA or VA exhibit. But if it is conventional, you don't need anything else. So back up here. What happens? Where do you think those consequences are? Yep, you got it. In these standard terms. So in the standard terms, under these contingencies, buyer's general right contingency. Again, it says this contingency shall only be granted by the seller if the appropriate box is checked. And it does have what happens to address concerns, termination, accepting as is. Appraisal contingency. This contingency shall only be granted. Again, here I am on the standard terms. This contingency shall only be granted by the seller if the appropriate box is checked. And then it says, subject to the expiration date, what if the buyer does not receive appraisal of the property that shows the value equal to or greater than the purchase price? Here's where you have termination rights and so forth and so on, and timeframes for the termination rights. Financing contingency. What happens if the buyer can't convince a lender to lend them the money? Well, here's all the termination rights, the loan denial letter, so forth and so on, what can be included in that loan denial letter. So again, I hope I am impressing upon you the importance of attaching the standard terms. Okay, Charlotte, great question. Wouldn't the FHA or VA exhibit override the appraisal contingency? Well, let's just look at the FHA and VA exhibit in the RE forms. You guys do not assume anything. You've got to read your contracts. Here's the RE forms FHA exhibit. And there's no time frame, because where's the time frame? The time frame is actually in the, let me go back up here. The time frame is in, for the financing, is in the purchase and sale agreement. Here is more of the RE forms FHA loan exhibit. It says it must appraise for the dollar amount you fill in here. Here's the FHA mortgage insurance, what percent it is it added into the buyer's loan amount, added in. Here's the seller's obligation for repairs. Here's the seller's obligation for public water and sewer. Here is information on septic tank, arm's length transaction. Do you see anything in here about appraisal? No. The appraisal contingency is a completely separate contingency from a financing contingency. So what I think you are asking about, appraisal contingency, is, so, okay, I see what you're asking now. I apologize. But just in general, just so you know, appraisal contingency is a completely separate contingency. Okay, let me just erase everything I just said. So Charlotte, I apologize. So the FHA or VA, there is a thing, regardless if you are, okay, let me catch my breath, back up. We're going to finish this lender section, then I think we're going to take a break. If the, let me answer your question by talking about a conventional first. If you're getting a conventional, if the buyer's getting a conventional loan, all you fill out is this information. You fill out the financing contingency, you fill out this information here. If the property does not appraise, an appraisal contingency is a completely separate issue than a financing contingency. If the property does not appraise, in the standard terms, it says if it doesn't appraise, a conventional loan, the buyer does have the right to terminate the contract. Now, the buyer can ask the seller to sell it for lower, but the buyer does have the right to immediately terminate the contract if they do so prior to that time frame, and they will get the earnest money back. If the buyer is getting an FHA loan, you fill that information, you still fill out this information in the purchase and sale agreement, but you do include the FHA or VA exhibit. Here's the FHA exhibit. In any FHA insured loan or VA loan, regardless if you are binding under the RE forms or the GAR forms, there is an issue for an appraisal that is called an amendatory clause. And in the RE forms, let me make this a little bit bigger so you guys can see it. This is the amendatory clause for an FHA insured loan in the RE forms. And basically it says the property, the FHA appraiser must appraise the property for at least whatever this dollar amount is. It goes on to say the buyer shall have, it says, if it does not appraise for that amount, the buyer shall not be obligated to complete the purchase or incur any penalty of forfeiture by earnest money. In other words, if the property does not appraise for this dollar amount, the buyer may terminate. Now, you can't just not do anything. The buyer must send a termination notice to the seller prior to the closing date, terminate the contract based on a low appraisal. The buyer will get their earnest money back. Now, the buyer does have the option of bringing additional cash for the difference and going on to close, but the buyer's earnest money is protected on an FHA insured loan, and the same is true on a VA insured loan in both GAR and RE, because these are federal agencies, and the federal agencies supersede any specific contract. And here's here is the VA loan exhibit on the RE forms. And it says, it is expressly agreed, buyers shall not incur any penalty by forfeiture of earnest money or be obligated to complete the purchase of the property if the contract purchase price exceeds reasonable value of the property as established by the VA. So I apologize, Charlotte. I was answering a different question in my head. But yes, so a buyer's earnest money is protected on a low appraisal, regardless of the contract form under which you are binding, but the buyer must terminate the contract prior to closing date. You can't just do nothing. All right. No, an amendment is not required. Well, the termination, you would have to terminate. Now, if the property appraises low, buyer's getting a VA or FHA or VA insured loan and wants to proceed, then you would the buyer just has to bring additional cash to closing. All right. My point is that I wanted to show you is that 2 points. Number one, there are 3 built-in contingencies in the purchase and sale. But the terms, all the ins and outs, the information your buyers and sellers need to know is contained in the standard terms. All contingencies are subject to an expiration date of that contingency. Again, FHA and VA, however, do go through day of closing. This appraisal contingency, if you have a time frame for here, but a buyer's getting an FHA or VA insured loan, the exhibit does supersede the purchase and sale agreement. So again, this appraisal contingency deadline is for conventional only. A low appraisal FHA VA insured loan go through day of closing. That's on the RE forms and on the GAR forms and actually any contract. All right. So one more thing about financing, and then we're going to take a break. I have a note here about switching between the GAR and the RE forms with respect to these contingencies. The RE forms package does have a financing contingency exhibit, and they do have an appraisal contingency exhibit. You agents who are familiar with using the GAR forms, do not get confused by these separate RE forms exhibits. As I have repeatedly said, the actual financing and appraisal contingencies are in the actual contract itself. You do not need any additional exhibit other than if the buyer is getting an FHA or VA insured loan. Just for conventional financing and for an appraisal contingency, you do not need any additional exhibit. It's all the information is contained in a combination of the contract and the standard terms. However, then it gets confusing because the RE forms does have this document, appraisal contingency exhibit and financing contingency exhibit. Why on earth are these in existence? Well, they are in existence for the switcheroo. Dana, what do you mean by the switcheroo? Well, as we've already had a discussion, if you are representing a buyer and you write an offer on the RE forms, and let's say the seller makes a counter offer by rewriting everything on a GAR form, but they don't really understand the RE form. So all they send back, all the seller sends back as a counter offer to your buyer is the GAR purchase and sale agreement. And they do not include any in GAR, the financing you must do, contingencies you must do by a separate exhibit. So they don't include any separate exhibits. So you're the buyer's agent. You get a counter offer back from the seller that's written on a GAR form. That's just the GAR purchase and sale. Well, your buyer might be fine with all the other pre-printed verbiage of the GAR purchase and sale, including the 8-day unilateral, so forth and so on. But nevertheless, you have no financing or appraisal contingencies for your buyer. In that situation, with respect to the switcheroo between GAR and RE in a counter offer type situation, you as the buyer's agent, you could then pull out, this is the reason these were created, the RE forms financing contingency exhibit and the RE forms appraisal contingency exhibit to make that contract subject to those contingencies. That's the only reason those are in existence, is for the switcheroo. All right. Oh, no, from current slide. All right. Those, talked about that, talked about that. All right. Whew. Let's take a break. All right. So welcome back. Welcome back. All right. We have discussed a lot. We are going to continue on. I hope you guys, I should have asked everybody. Usually I have three kinds of students in this course. Number one, I think everybody should take this course because, as I mentioned at the beginning, there are a variety of real estate contracts here in Georgia that buyers and sellers use to go binding. There are forms that are copyrighted and licensed by the Georgia Association of Realtors. There are these forms that this class is, the RE forms, again, sometimes referred to as the FMLS forms. There are HUD contracts. There are Fannie Mae contracts, Freddie Mac contracts. There are new construction contracts, the majority of which are authored by the Atlanta Home Builders Association. There are attorney written contracts, investor written contracts. There is a variety of contracts. However, predominantly speaking, there are two sets of contract packages that you as agents have readily available access to initiate an offer or counter offer, and that is the GAR form and the RE forms. Neither one of these packages is going away anytime soon. So I believe that you as an agent are enhancing your own personal professionalism as well as the integrity of our industry here in Georgia by being as well informed and well versed on the contracts that are available. These are your tools. You know, an artist has paints and brushes and clay and whatever medium an artist uses. A dancer has their feet and their body. A musician has whatever musical instrument. There's all sorts of tools that artists use. The contracts are one of your tools as a professional real estate agent that you use in your industry. So you need different tools for different things. If you're an artist, sometimes you're going to use a big old fat brush and acrylic paint. Sometimes you're going to use a little fine brush and watercolors or different acrylics. So there's different tools that you need based on what it is that you are trying to achieve. So learning more about these, there's no poll, you guys, I apologize. We are not going to have the poll, so just don't worry about that. Yeah. There's no questions. You guys can just put in the chat your experience with the class, if it was worth your time, well organized, just in general. They want to try tweak something. Okay, wait, Heidi says she tweaked something. Let me, no, I still can't get it, Heidi. It's okay. It's done this before. I'm not sure what happened. So, okay. Anyway, so as your tool, so I love that you guys are taking this class to learn about this, but typically I have three types of agents or three situations where agents take this class. Number one, they predominantly use the RE forms and want to learn more about them. Number two, they predominantly use the GAR forms, but they want to learn about the RE forms because they get offers on the GAR forms, and either their clients want to accept them and they're just not sure what's in them, or they just want to understand a little bit more about them. Or third, I've got agents that just need CE credit and this fit their schedule. So thank you guys very much. So regardless, I hope I am covering the information to accommodate all of you all. All right, so now we are going to move on. So now I'm going to share my screen again. Thank you guys for the kind compliments. I do love teaching, and that is one of the things that is one of the most enjoyable things about my job. So I appreciate your time and attention. And I know you have a variety of classes that you have the opportunity to take. And, you know, 3 hours is a lot of time, and hopefully it's going by fast. All right. Yes, there will be CE credit. Yes. But even though we don't have a poll. All right. Good job, everybody. Continuing on. Now, Georgia in general is a caveat emptor state. That is just a fancy Latin phrase that means buyer beware. Now, Georgia being a caveat emptor state, that is for any purchase, you guys. That is for real property. That is for personal property. That is for a car. That is for things you buy at a store, any kind of store. And basically what that means, there's no laws, there's no return laws. If you buy something at a store and you go to return it, even if you have a receipt, the store does not have to take that back. It's not Georgia law. The store might have a policy, a return policy if you have a receipt or a certain amount of time, or if it's an unopened package, blah, blah, blah. But that's what it means, caveat emptor, buyer beware. The buyer needs to make themselves completely satisfied with the product or service that the buyer is purchasing before exchanging money for goods or services. Now, without going too much, I need to get back to the contracts. There are certain legal rights of return for used cars within a certain amount of time, and if it's a lemon, for real property, there's only two rights. Well, for purchasing real property, there's only one legal right of rescission, and that is if a buyer is the very, very first buyer of a condominium. That's not a style, that's condominium ownership. They have a right to quote unquote return it or unwind the contract within 7 days. And the only other right of rescission isn't actually returning real property, but you can undo a refinance within, I believe it's 7 days. But anything else, once you buy it, you buy it. You don't have the right to return it. So in Georgia, our contracts, the RE forms contract, that's why we have that provision of buyer's right to terminate. That gives the buyer an opportunity to check out the property. A buyer's right to terminate or due diligence is, you guys are very, I'm very humbled by your comments and honored to teach. I'm looking at them at the side, and I really, very, very humbled and honored by your comments. And I thank you, and I do give glory to God for talents that seem to come through me from God for being able to convey information in a way that is enjoyable and informative. So thank you guys very, very much. Okay, so a due diligence period or buyer's right to terminate is the buyer's time to help them make the decision. Am I going to go through with this property, with this purchase, or am I going to terminate and protect my earnest money? So there's all kinds of things a buyer is going to do to help them make that decision within that time frame. One of the things the buyer is going to do is have an inspection of the property. And that's why it says the buyer has the right but not the obligation to inspect the property. And the seller agrees to let the buyer in. Now, in the RE forms contract, it's a little bit different. It has either from 9 a.m. to 7 p.m. or fill in the blank, which would be a different time frame. We are still in daylight savings time through November. I believe it's November 3rd, whatever that first weekend is in November. So it stays light out through like 9, 10 o'clock at night. It's getting shorter. Our nights are getting shorter, but our days are getting shorter. So when you are in this time frame, you might want to put in through 9:30 at night or 8 p.m. or something like that. Once we switch back to standard time, then a lot of times this 9 a.m. to 7 p.m. is really effective because usually it's a little too dark for any type of inspection after 7 p.m. Just so you guys know, my understanding is they passed a bill that for Georgia to stay permanently on daylight savings time, but it hasn't been signed into law. So I just looked it up actually last week. And so we are still going to have to fall back in November. But there is a push for ongoing legislation to stay on daylight savings time. Okay, that's neither here nor there, just because it came up. Now, here's another thing. This says, make sure these little checkboxes are difficult to see. Buyer or seller shall make all required utilities operational and available on the property through and including day of closing. Why through day of closing? Well, first of all, you're going to need inspection done and appraisal done, but through day of closing, so you can do a walkthrough. But just make sure that you write who is going to be responsible for those utilities. And then in general, the buyer's responsible for doing your own due diligence and checking out if the property was registered as a meth lab, violent sex offender list. I'm telling you guys right now, gbi.georgia.gov, you can look up the violent sex offender list. It's a frightening list. And if you put in your own property address, you might put your house up for sale. So this is important for a buyer to know. These things often get overlooked. Again, if you are an agent and you are working with a buyer purchasing a property and they've got young children, you might want to make sure that they're aware of this and that this is public information that they can look at. All right, moving on to the brokerage section. This is where a material relationship you're going to describe. This is a relationship that either your broker has or you as an agent have with the public that's just a little bit more than just a client or customer. For example, if it is a family member, if it is a business partner, I also highly encourage that if you are working with a buyer or seller and they are a past client of yours, that you mark material relationship. And this can be very general. Like if you're working with your sister, your brother's second wife, or your brother's mother's aunt, well, you don't have to put it that specifically. You can just put agent is related to buyer by marriage, or buyer is past client of agent, something like that. It can be generic, but you need to disclose the material relationship. And then under the brokerage part, we've already discussed this a little bit. Per Beretta, which is law in Georgia, Georgia Code 10-6A-1, a public person becomes a client of your broker and hence you by signing a document. They must sign a brokerage agreement. If it's a buyer, it's a buyer brokerage agreement. If it's a seller, it's a seller brokerage agreement, which those forms are also in the RE forms contract package, but we're not going to discuss those here today. You must disclose per license law. If you are working with a public person as a client, you must disclose that in the contract with the offer. Now, I'm pointing this out specifically because here are fill in the blanks. If your public person does not sign a brokerage agreement, then you are working with them as a customer. If the buyer has signed a brokerage agreement and the seller has signed a listing agreement, you're working, and there's only you as the agent, you're working with them as a dual agent. If the seller has signed a listing agreement with your firm and you are working with the buyer to sign a buyer brokerage, both in the same firm but different agents, it's designated. Again, you must disclose a client relationship with your public person in a contract, and you must do this at time of offer. That is license law. The RE form has the fill in the blanks for this. If you are an agent involved in a HUD contract, new construction, so forth and so on, this is still license law, and you need to disclose if you are working with your public person as a client. So you're going to have to add that in as a special stipulation. All right, wire fraud disclaimer. Our industry is fraught with wire fraud. Basically, there are disclaimers in the contracts, and in essence, you just want to make sure your public, it's mostly for buyers because they're emailing, they're wiring typically earnest money and cash for down payment. But you guys, you sellers agents, this is for sellers too, because a lot of times the closing attorney will ask a seller for wire instructions, either to wire them proceeds, or if a seller is doing a back-to-back closing and the seller has to provide the closing attorney with wire information for the next closing attorney, You need to tell your public people, be very, very, very wary of any wire information they get. They should never get, you guys never, ever, ever as an agent send wire instructions by email. It is our emails that are getting hacked. You need to either physically hand them to your people in person, you need to send them by US mail, or you need to have them go to their bank, pick up the phone, call you, and you voice the wire instructions to them over the phone while they are there at the bank. It's the emails that are getting hacked. And a lot of brokers and a lot of closing attorneys will not email wire instructions anymore. You need to tell your public people, never trust wire instructions they get via email, never trust a change in wire instructions, and never trust wire instructions they get by text. Very, very important. And then you would reference the exhibits that you are going to use, and you write out any special stipulations. Just a couple notes on exhibits and special stips. Secure logins are not secure, Angela. Look at our government computers getting hacked. They are not secure, and I would not trust even an encrypted site. And again, many even closing attorneys are not even sending out wire instructions via an encrypted site. The safest way, you guys, wire instructions do not change all that often. Go by your broker, go by your favorite closing attorney, get the wire instructions in paper, make several copies. When you first meet with your wire, hand them to them so you'll have them even before you find a property. And just check, and before they're supposed to wire money, just call your broker and say, hey, I've got the wire instructions from earlier in this month. Have they changed? Your broker will say no. And you're like, great. It is the emails that are getting hacked. Okay, so moving along, exhibits and special stipulations. Exhibits will supersede a purchase and sale agreement, and special stipulations will supersede an exhibit. Therefore, do not use an exhibit for an issue that is already addressed in the contract, because if you have something different, you could negate what your initial intention is. Additionally, do not write a special stipulation for an issue already addressed. What do I mean by that? Okay. We already talked about in the purchase and sale agreement in the RE forms, we've got appraisal contingency financing. So the appraisal contingency time frame is here, and what's involved in the appraisal contingency if it appraises low is spelled out in the standard terms. Okay. We already mentioned too, right before break, if there is an appraisal contingency exhibit, but it is really only for the switcheroo. If by accident you fill out information in the contract for the appraisal contingency and then also attach an exhibit and it's different, this exhibit is going to supersede. So let's say, for example, in the purchase and sale agreement, you put an appraisal contingency here of 21 days. But then you mistakenly also used an appraisal contingency exhibit, and here you put 14 days. Well, guess what? The exhibit is going to supersede the contract. You have just now shortened your buyer's appraisal contingency time frame from 21 days to 14 days because this came after. Additionally, for a special stipulation, there is an entire library of special stipulations that you can use. I'm back here under the RE form. I'm back here under Remind Docs. I'm back on in FMLS under Remind Docs under Forms Library, and I'm going to click on Georgia. I'm going to click on RE Forms, and let's see what some of those special stipulations are. So I'm going to click that magnifying glass, and when you are searching in sites like these, the less information, the better. So I'm just going to put in STIP and hit enter. And here I get the entire, okay, that was the Georgia Association of Realtors. I am going to get the entire library of special stipulations that are available in the RE forms. And I can look to see what the topics are. You can download this as a PDF and keep it. But here is, for example, appraisal review, assignment right of buyer. These are all alphabetical. Buyer to list existing property, contingent upon obtaining a building permit, Earnest money to become non-refundable, earnest money to be increased, lease purchase, so forth and so on. There are a lot of special stipulations that I suggest you look to see if there's already something in the library before you write something. If not, I suggest you go to your broker first. And if not, then you will want to contact a closing attorney. The reason I say this is a lot of times you have all good intentions, but they're not complete. So for example, you will write, and again, a special stipulation is going to supersede an exhibit, which supersedes a contract. So for example, let's say you have the appraisal contingency in the contract, and and then you write a special stipulation that says property must appraise for sale price, and that's all you write. Well, what happens if it doesn't? Are there termination rights? Are there notices? Are there time frames? Does one party get to negotiate with the other party? Well, who knows? Because you did not include all of that in your special stipulation. And because you addressed appraisal, you've just now superseded all of that information, all of that legalese, and all that information that we've covered that was written by attorneys. So be very, very cautious of using special stipulation. And then time limit and acceptance date, which is the same concept as a binding agreement date. In the RE forms, here is the time limit, and it says it is open for acceptance with no changes. So if a buyer writes an offer to a seller and they have a time limit today of 6 o'clock, and let's say the seller makes a counter offer, then it doesn't matter. The time limit is of no consequence. The time limit is only for no changes. For example, let's say Macy's has a sale on purses, and let's say they advertise this sale on I don't know, some designer purse that's normally $600, and Macy's advertises this purse is on sale for $200 till 6 p.m. tonight. And guess what? I am teaching this class, and then I've got to go back to my broker duties and so forth and so on. I can't get to Macy's until, Macy's is open till 9. So I can't get to Macy's until 7 o'clock. But I've got this document, I've got this ad that says this purse, this designer purse is on sale for $600 purse for $200 till 6 o'clock. I get to Macy's at 7:30. I go get the purse from the shelf, bring it up to the counter, pull out my flyer that shows it, give them $200. And the cashier says, thank you so much, but you still owe me $400. And I'm like, no. Here's the document. It's for $200. And the salesperson says, no, that offer is only open for acceptance until 6 p.m. at night. That's what a time limit is. It's not a time for a response. It's not a time for a counter offer. It means these terms as presented with no changes are open for till 6 p.m. at night. If a seller makes a counter offer, then that is a new offer, and that would have its own time limit. If the seller accepts, let's say the seller wants that offer, but they don't sign, let's say the time limit was 6 p.m. tonight, seller doesn't sign it till 7 p.m. tonight. Guess what? Those terms were not open at 7 o'clock tonight. So in essence, what that did is that made it a counter offer back from the seller to the buyer, and you will need to go one more round for signatures. And then here is the place for the accepted contract, which is the same concept as a binding contract and demonstrates a meeting of the minds. All right, we've already talked about this, about the RE standard terms, and here's where you sign it. Standard terms. Okay, I've already talked about a lot of these things in the standard terms, but just so you know a little bit more about what is there, which has, we've got 15 minutes. So just a little bit more about what is in here. The type of title that is conveyed is good and marketable title by limited warranty deed. Good and marketable is defined here, I'm in the standard terms now, as ensure one that a title company License to do business in Georgia will insure at its regular rates, subject only to standard exceptions. We've talked about what happens if the buyer doesn't send the earnest money or if it bounces from the bank. We've talked about that. We've talked about that too, about what happens to the earnest money if you don't go binding. You either do a TNR or 10-day letter or court arbitrator. We've talked about that. And again, one of the handouts I'm going to email you guys is a PDF of all of these slides. These are closing costs, and basically the seller is responsible to pay anything that would be required to clear any title defects. Just as normal in Georgia, buyer and seller at closing agree to prorate taxes and all that information. Buyer shall be responsible for payment of all the other costs, fees, and expenses if not otherwise provided. Seller's responsible for the costs associated with their side of the closing. Now, when a seller does make a contribution to a buyer's closing costs, this is another kind of big difference in the GAR and the RE forms contract. In the RE forms contract, whatever dollar amount a seller agrees on the contract to contribute to a buyer, the buyer gets the full use of all of that money. It says closing cost allowance can be used subject to underwriting criteria. The lender uses it, in other words, first for prepaids, escrows, and closing costs. But if there's money left over, the buyer can use it for any purpose whatsoever to offset any costs incurred merely at the discretion of the buyer. What does that mean? That means if there's money left over that a seller is contributing out, left over from closing costs, prepaids, and escrows, the buyer can use that contribution to pay HOA dues. They can use that contribution to pay their hazard insurance. They can use that contribution. That basically buyer gets the full dollar amount that the seller is contributing. In the GAR forms, if it is negotiated X amount of dollars and the closing costs, prepaids, and escrows are less than that, the leftover money does go back on the closing statement to the seller. We've talked about all of this. And in the buyer's right to terminate, there is an offer that, again, this is the buyer deciding, are they going to terminate the contract and get their earnest money back or go through with it? There is the opportunity. The buyer shall also have the right, but not the obligation, prior to the expiration of this time frame of this contingency, to send an amendment to the contract to ask the seller to address concerns. So you guys, when you see the term as is, that typically means a seller is communicating they are not going to do any repairs. That does not mean the buyer still has the right to inspect the property. Talked about that. We've talked about the appraisal contingency. And again, if there is a big difference in a conventional loan between the RE forms and the GAR forms. If a property appraises for less than sale price in the RE forms, the buyer may just immediately terminate, get their earnest money back as long as they send notice of termination prior to the expiration of this contingency time frame, and they'll get their earnest money back. In the GAR forms, conventional loan, appraisal comes in low, the buyer must give the seller the option of selling it for the appraised price. If the seller says no, then the buyer may terminate. If the seller says, yes, I'll sell it to you for less than sale price, then the buyer must go through with the contract. So that's a little bit difference between the GAR form and the RE form. We've talked about the financing contingency. Just so you know, though, in the financing contingency, if a buyer cannot convince a lender to lend them the money, they have to send notice of termination based on the financing, and they have to prove it with a loan denial letter. However, that loan denial letter, there's very specific information that must be included. The loan denial letter must be a denial of the loan as described in the contract, and it has to be a denial based on standard underwriting criteria. If the lender's loan denial letter says it's because the buyer doesn't have enough down payment, cash for down payment or closing costs. It's adding salt to the wound. The buyer is not going to get the house, but their earnest money is also not protected. They will lose their earnest money because that does not meet the terms of a financing contingency. If the buyer has a house to sell and there wasn't a separate sale or lease contingency exhibit, and that's the reason they're getting denied, they will also lose their earnest money. Now, this one's really interesting. Buyer's conduct after acceptance, but prior to this contingency. What on earth does that mean, Dana? Well, I'll tell you what that means. That means that your buyer is under contract. The lender has pulled their credit. They've got great credit. Their debt to income ratio is great. And then they're all excited about their new home, and there is a Labor Day sale. Rooms to Go or any furniture company has a Labor Day sale. Buy a whole house full of new furniture, same as cash for 90 days or 6 months. Guess what? That still hits a buyer's credit report. So if the buyer goes and buys stuff on credit or sells a car or buys a car or something like that, that is buyer's conduct after acceptance date, but prior to closing date. If that throws off their credit scores or their debt to income ratio to where a lender no longer is going to finance them, unfortunately, they're not going to get the loan. They're going to terminate the contract, but they will also lose their earnest money. Now, I don't see this a lot lately, but actually we have an ongoing issue right now with one of our buyers who is getting down payment assistance funds. Remember I said, and this is in the contract, this is in the standard terms, this is also in GAR 2. It says that a buyer not having sufficient funds for down payment or closing costs does not meet the terms of a financing contingency. In other words, they're going to lose their earnest money. If you are working with buyers getting down payment assistance funds, that's not part of a financing contingency. So if you are working with buyers getting down payment assistance funds, you must add a special stipulation to protect your buyer's earnest money that states this agreement is contingent upon buyer's approval for the receipt of down payment from whatever program, like Georgia Dream or whatever, within so many days from binding agreement date. Should buyer not be approved for the down payment assistance program within that time frame, buyer may terminate without penalty if buyer notifies the seller in writing and provides the down payment assistance funds denial letter. Again, just so you guys know, down payment assistance coverage is not, down payment assistance, that whole program is not covered in a financing contingency. We've talked about that, talked about that. Talked about that. We've talked about a lot. Talked about that. Talked about that. Talked about that. Talked about the VA loan. All right. We've talked about that. Okay. Let's talk about repairs. In the RE forms contract, it states, this is in the standard terms now. It states that if the buyer and seller did negotiate for repairs, the seller has agreed in writing by contract to perform any repairs, they are to be completed in good and workmanlike manner and shall be completed no later than 3 days prior to closing. Unless otherwise stipulated, the property shall be in the same condition on the date of closing as it was the date of acceptance, which is binding agreement date. Normal wear and tear accepted, and broom clean with all garbage, debris, and personal property and belongings of the seller removed. So what does this mean for you buyers agents? This means that if you have negotiated for repairs, you really need to do 2 walkthroughs. You need to do 1 walkthrough at least 3 days prior to closing just to check. And if things are not done at that point, you either need to amend to have that done or addressed, or do another walkthrough date of closing. But this is just a little bit of cushion time for your buyer. So you're not doing a walkthrough the morning of closing and stuff hasn't done. And you have all sorts of high emotions day of closing. Here's where it talks about if the property was substantially damaged prior to closing. That means destroyed by a weather issue, fire, tornado, hurricane, tree falling on, yes, 5 days, longer before closing might be better. If the property is, okay, let me go back to these questions. If the property is deemed ineligible for financing after the financing contingency, would the buyer lose their earnest money? Yes, the buyer only has, the buyer and seller negotiate that the buyer has X number of days from binding agreement date for the, now a financing contingency is an assessment of the buyer. An appraisal contingency is an assessment of the property. So a financing contingency means the seller gives the buyer X number of days to convince a lender to lend to them. The lender goes through and looks at the buyers, how they handle their money, and says, am I willing to take a risk on you and think that I'm going to lend you hundreds of thousands of dollars and you're going to pay me back? That's what a financing contingency is. An appraisal and then a lender says, but just to hedge my bet a little bit, in case I made a bad decision, in case I decide to lend you the money anyway, but made a bad decision, I'm going to take the house back as collateral. So if I made a bad decision and actually took a risk on you that was a bad risk on my behalf, and you default and you don't pay me back, then I get the house, and I have to make sure that the house I get, I can turn around and sell it and cover the money that I lent to you to cover my losses. So a financing contingency is a lender's assessment of the buyer's ability to pay them back. Then they hedge their bets. In case the lender makes a bad decision there, an appraisal contingency is a lender's assessment of the collateral for the loan, saying, well, if I made a bad decision, is the house going to cover what I lent out so I can make myself whole? So a property deemed ineligible for a property has nothing to do with financing. And a property is going to be an amount for collateral. A buyer is going to be the assessment of financing. And it's up to the buyer to stay in touch with the lender. You only have so many days. If the lender says, nope, I'm not going to take the risk on you, but that time frame is outside of the financing contingency time frame, then the buyer's going to terminate the contract and they'll lose their earnest money. The seller only gave them X number of days to convince the lender to lend them money. So yes, they will lose their earnest money. Okay. So back to substantial damage to the property. If the property was damaged by, weather, a tree, major vandalism, so forth and so on, the seller is to restore the property to the same condition it was prior to closing, or they may terminate, or the buyer can say, I'm going to go ahead and close on it even with everything destroyed, but you're going to forward any and all proceeds back to me. Brokerage agreement, we did talk about that. It also says that the broker only owes the duty to the buyer or seller what is set forth in the brokerage agreement, and the seller and buyer each hereby represent and warrant to the other that they have not dealt with any real estate broker other than the salesperson on this contract. In other words, there's no other commission owed by anyone, owed by the that a broker can come to for anyone. In other words, the buyer is only working with one broker at a time, and the seller is only working with one broker at a time. A buyer and a seller who have not signed an agreement, they are considered a customer and must protect their own interests. But you agents, that's still, if a public person is working with a broker / agent as a customer, they have still chosen that company with which to work. That still doesn't mean you can cross assign. That does not give you free reign to contact their public person directly. It's just the legal nature of the relationship, and the duties owed are different. But that doesn't give co-op agents the right to contact another broker's client or customer. This is a broker's disclaimer of liability. It basically says, look, I am a real estate agent and I am a real estate broker. I am licensed as an agent and a broker. I am not an expert. I'm not a surveyor. I am not an inspector. I am not a zone person. I'm not an advice person. I'm not an attorney. Anything that you have that is of specific importance to you, you have the duty, you public buyer and seller, to go get other additional advice. structural advice, safety advice, title advice, financial, tax, legal, health, blah, 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 blah. Parties have not relied on any advice or representations from the broker or agent other than with respect to their duty as an agent. We talked about dual and designated default. If the buyer defaults on the contract, the seller agrees that their only remedy is the earnest money. They can't sue them for damages. Like if the seller has a moving truck lined up or has to say an extended stay or something like that, they agree not to pursue the defaulting party for that. Now they can, but their attorney should argue, look, when you signed this contract, seller, you agreed that if the buyer defaulted, you would accept the earnest money as the sole and exclusive remedy. If a seller defaults, the buyer has one of two options. In other words, if a seller just fails to close outside of any contract provision where they're allowed to terminate, then the buyer has a decision to make. Either, okay, I'm going to terminate, get my earnest money back, and I'm going to go find another house, or I can sue a seller for what's called specific performance. Specific performance means it's not money. Specific performance means they go to court and a judge rules that the seller must go through with the contract with this buyer. A note to you guys, if a buyer is going to sue a seller for specific performance, they don't get their earnest money back, because if the judge is going to make the seller go through with it, the earnest money is part of the contract. And my understanding, we just had this discussion in a sales meeting last week, at least in Cobb County, suits for specific performance are being heard anywhere from 6 months to 2 years. That's a long time for a buyer to wait to get this property. But both brokers may pursue the defaulting party for the commission they would have earned. Notices must be in writing, and an email notice is deemed received when the sender can prove they sent it. What time is it? All right. There is one, let me just point, I'm gonna finish up with a couple of things. We are at the end of time. One more time before you leave. I am gonna stay on and answer questions. I've got one more thing to address, so hang with me for 30 seconds. But before you do leave, also, I do need for you guys to type in one last time your name, real estate license, email address, and phone number. But one more thing, and this is really important, and this is a big difference between the GAR forms and the RE forms, the survival of contract. The survival means a party's legal obligations per the contract that continues after closing if they were not completed prior to the contract. In the RE forms contract, the entire contract survived the closing. In other words, in the GAR contract, it's very specific. In other words, for example, if in the contract, buyer and seller negotiate and it says at closing, seller to pay for a 1-year home warranty for a buyer, not to exceed $650 to be paid for by seller for 1 year, blah, 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 to be ordered by buyer's agent. And the buyer's agent forgets to call it in. You go to closing, you forget. And the buyer calls you and says, hey, I need information on that home warranty. And you're like, oh my gosh, we forgot to call it in. The buyer's agent calls the seller's agent and says, hey, I need for your seller to pay for this home warranty for the buyer that's in the contract. And the seller's agent says, sorry, that didn't survive the contract. And you're like, oh, you silly seller's agent. You must be thinking that we were binding on a GAR form. We were binding on the RE form. And in the RE form, the entire contract survives the contract. So yes, even though we have closed, the seller is still responsible financially for paying for the home warranty. So that's a big difference. We've talked about these. Just a couple of other things to let you know. We've already actually talked about some of these disclosures. The RE forms does have a community association exhibit that you will want to use because the seller is obligated to disclose any and all fees associated with the HOA. Any fees the seller does not disclose on the community association disclosure exhibit the seller will have to pay at closing. Lead-based paint disclosures, seller's disclosures. That's the community association disclosure. There is a backup contingency sale or lease contingency. There also is, just so you guys know, in the RE forms for there's an amendment during the buyer's right to terminate. I'm going to send you guys all these notes. Okay. One more thing I need to let you guys know. In the RE forms, when a buyer is terminating a contract, there are two separate forms. There is the notice to terminate, which is RE 263. And then there's the agreement to release the earnest money, which is RE 212. In the GAR forms, for those of you familiar with GAR, both of these two separate contractual issues are handled on one document. In the RE forms, there are two separate agreements, two separate documents. The notice to terminate the contract is unilateral. It only needs one party's signature. But per license law, as well as per the contracts, an agreement to disperse the earnest money, RE 212, does need both parties' signatures, and you fill out who the earnest money gets dispersed to. Talked about that. Consumer brochures, we've talked about that. So I hurried through some of the other ancillary documents, but we did actually cover it all. I want to thank you guys. I just want to remind you guys to confirm any and all contract questions with your broker. Please check out our online calendar for additional CE classes. If you go to there and click on Marietta, you will get the master calendar for all courses, including all virtual courses. These are offered through the Georgia Real Estate Academy. Again, a virtual class credits. I have 3 to 5 business days, and I told you 1 to 7. They should be done within 5 business days. And my YouTube channel. So, whew, we made it. I talked really fast at the end, but I believe we covered really, really important concepts, especially dealing with earnest money at the beginning. I will be more than happy to stay on to answer any questions. Again, I thank you guys for your attendance. I hope for those of you using the RE forms, you got a better understanding of them. I hope for those of you using the GAR forms, you got an understanding of the RE forms. For my agents, for any agents on here who have been practicing real estate for over 20 years, you should start to see that those RE forms look an awful lot like the GAR forms from about 15, 20 years ago. Regarding which is better or worse, again, it's very specific to your buyers and sellers, and that's why you as a professional real estate agent owe it to yourself professionally and to your industry and to your clients to be more familiar with one over the other. There are both of these. Oh, that was my pop quiz question. Who are these contracts designed to protect? And the answer is both the GAR and the RE forms contract packages are designed to protect you, the agent, and your brokers. The reason is the majority of all that pre-printed stuff, not only for public disclosure, but contains a lot of elements of license law that you need to disclose to protect yourself, and so that you stay in compliance with license law. I will say the GAR contracts have a longer history of use here in Georgia, but that doesn't mean that that the RE forms are bad contracts. They're just a little bit different. Just like my gosh, if we're looking at that, there are some new construction contracts that are horrible for our buyers. There's no due diligence period. Once they sign it, basically their construction deposits and earnest money are basically at risk if they fail to close. There's very few contingencies, very limited contingencies. A lot of the new construction contracts, the builders can change anything once a build. Some of them have, if it's ground up construction, once the builder gets the CO, the builder can close within 3 days. If a buyer's not ready to close, the buyer will be in default. There's all kinds of crazy things. So it's not a question of better or worse, good or bad. It's a question of understanding what is in that contract and how that relates to your clients or customers' needs. And is your client or customer willing to accept the promises, the provisions, and the potential consequences for those things? So yes, protect agent and broker. Yes. So I thank you guys so much. If you have any questions, stay on. Again, if you are leaving, yes, any of you are free to go. Again, one more time, please type in your name, email address, real estate license number. If you do have a question, because everybody is typing stuff in to the chat, you may unmute yourself. Just mute yourself back so everybody can hear the question and the answer. And I thank you guys so much for your time. Don't get freaked out by the news. Stop watching the news. There are plenty of buyers and sellers that need the blessing of you and your real estate license. Don't worry about these hedge funds. Don't worry about anything. There are people that real estate is a relationship business. It's complicated even among the most experienced professional agents. And so the public without experience and training absolutely need your help. All right, any questions? I will email you guys all the notes, including for those of you that are experiencing some misinformation out there from some of your co-op agents or colleagues that say their broker only accepts GAR contracts. In the documents I will email you, I will also include, again, references to license law, Realtor Code of Ethics regarding the presentation of offers. And there's a lot of information on that that you can professionally and kindly present to your co-op agent. And if it still becomes an issue, have your broker contact their broker, and I guarantee you it will get, I don't guarantee, but I would imagine in 99% of the situations, it will get addressed and worked out. All right. No questions? Thank you guys so much. Have a great one. Bye, everybody.